title of our webinar today is How to Read a Contract Like a Boss. And what we're focusing on today is how to approach a contract, really understanding the structure of the contract and what to keep in mind as you go through your contract. This is a foundational webinar for those that are new to reading contracts, but also for those that are intermediate or experienced and want to learn some tips from our panel of pros. I will be moderating today's session, but what you should anticipate is an open, really roundtable discussion amongst our panelists. We all also want to hear questions and even stories if what we're talking about today resonates with you. So use the Q&A chat function at the bottom of your screen, and be sure to leave some. We'll be sure to leave some time at the end of the call. So welcome to our panelists. I'll hand it over to you, Geza, first, to maybe introduce yourself, and then we'll go around the table.
Thanks, Amber. My name is Geza Banfai. I'm a construction lawyer, counsel at the Toronto office of McMillan LLP, and I participate with the CCA a lot. I'm on CCDC, and I've been doing this for a long time. Who's next? Trevor?
Sure. Hello, everyone. My name is Trevor Osphew. I'm a pre-construction manager with Graham in our Edmonton office. Big part of my job is being involved on the front end project setup side of things. So I'm often involved in contract reviews and negotiations. And prior to this role, my job was executing projects through the construction phase. So I got a lot of scars from learning lessons the hard way. So nice to meet everyone. I'll pass it off to Katie.
Thanks. Hi, everyone. My name is Katie Fairley. I'm the principal of Fairley Strategies. I'm also a recovering general contractor and have the fortunate and unfortunate experience of working with a number of public sector owners. But most importantly, I am the industry standard practices consultant with the BC Construction Association. And yeah, always happy to remind folks to read their contract as well as use their contract.
Thank you, Geza, Trevor, and Katie. So for our first topic, I think we'd like to discuss what should we have, or if we should have a written contract versus, let's say, a verbal contract or no contract at all. Why is that important? And maybe I'll start with you again, Geza. Sorry, Geza, you're on mute.
Sorry. Why you should have a written contract at all? There's no law, with some minor exceptions which don't presently apply, that says that you can't do a construction project on a handshake. You can. It's bloody dangerous. That's the theme of this webinar. In fact, it's the theme of this whole series of webinars. There's real value in a written contract, and it goes without saying, but it should be said, that there's real value in reading and understanding the written contract that you're signing, and that too is a big part of the theme of this webinar. There are I won't monopolize this, but there are a number of good things about a written contract beyond what seems obvious. The obvious is it's a record of the deal that you made. Great. You need that record for various reasons, not least of which is if you find yourself in a dispute. But even if you don't find yourself in a dispute, the record of the deal is important because it's a roadmap for the troops who are actually going to perform the work. The commercial people, in my experience, who negotiate the contracts very often, perhaps more often than not, are not the people who actually execute the job. So the people who execute the job need to know what the rules of the game are. And that's what's sitting in the written contract. But there are other benefits. And I'll just point out to one of them. Simply negotiating a written contract is an extremely valuable exercise, because it's, as I like to think of it, it's a form of dispute avoidance or dispute resolution or conflict resolution at a time when it's safe to do it. You know, resolving your conflict after you've entered into a contract is a whole different ballgame, as I'm sure the audience is very attuned to. It's expensive, it's uncertain, you're locked into a legal relationship, and so on and so on and so on. But at the contract formation stage, when you're negotiating a contract and the parties go through the commercial and the legal terms of their relationship before they have locked themselves into one, is the perfect time for each to ask themselves and to ask the other, what if, you know, what if you burn my building down? You know, what happens then? What if you don't perform? What if there's a delay? What if? And the act of asking those questions and then answering them by reference to a draft of a written contract is incredibly valuable, because it gets the parties more on literally the same page of their relationship. So that to me is a tremendously valuable function served by a written contract.
That's great,
Anybody?
Geza. I think what I've heard is it's less form over its substance, right? Whether it's written down on a napkin or written down, you know, or it's verbal, what you want to have is the negotiation. You want to be able to have a discussion around what the pain points are and the substance of the construction and the work that you're going to do.
Yeah.
Trevor, as a current contractor, and Katie, I'm going to maybe go back to you as a recovering contractor, is, you know, what's your thought process around this?
Yeah, 100% agree with everything Geza stated there, like the covering off all the different what if scenarios during the negotiation phase before you signed off on a contract is essential. Like, you know, what if one party's not performing the job they said they would do, not paying, leaning the job, going insolvent, sorting out how to handle those situations when things don't go according to plan, or stuff that aren't covered in a handshake deal. And I like his comment around roadmap for the troops. One of my favorite analogies is that construction's like a really complicated board game, and the contract is the long and often boarding rules that no one wants to read. But you can't play the game if you don't know the rules. So having those in place and making sure we're reading them up front is essential.
And Katie?
Yeah, I think building off of what Geza and Trevor have said, I think we could also have labeled this slide and this initial discussion about why to have a standard contract, either a CCDC or a CCA1, as your base point to you know, build off of and hopefully not modify too much. But I'm sure there's a lot of people on the call thinking, you know, we don't have an opportunity to negotiate. We are given these contract terms at the time that we bid. They're dictated to us by the owner down, you know, through the GC. And I think, you know, my message would be, you don't know unless you ask. You don't know unless you raise those concerns, you know, at the time of bidding, before you bid, and then certainly before you sign. And one of the big items that I hear about people, why they don't push for a written contract or don't push for that negotiation and asking questions, is because they're, you know, they're concerned about upsetting this relationship. And, you know, I would kind of put to everybody here that one, it's not personal, it's business, and that contract can protect your relationship. And I think that's why it's important to have one. And then, of course, you know, can't say it enough, also read it as well.
Thank you, Katie. Trevor, I'm not sure how I feel about your board game analogy. It's, you know, hopefully it's not a zero-sum game with a winner and a loser, but sometimes it can feel that way, can't it?
Yeah, there's always one or two people that are the rule readers. I'm unfortunately one of those that delays the game for everyone else to start. But yeah, it's important nonetheless.
There's a lot that goes into improving on your skill set and becoming an effective reader of a contract, particularly if you're a beginner. It can seem very overwhelming. But can you maybe talk a little bit and share your experiences? You know, you guys are pros now, but you had to develop these skills as well. Maybe give a lens to some of our beginners, or share some pro tips on how to read a contract effectively. I'll maybe start with you, Trevor.
Sure. Yeah, I like the note on about reading it at least twice. That's excellent advice. First time, just kind of for base understanding, and you'll always pick up a lot more nuances or connectivity between the different clauses on that second pass. And I always love going to my project teams and seeing a hard copy printed out full of highlighting and full of notes. That's how you know they've read and really understood the contract. And all contracts aren't the same, even when it's a standard form CCDC contract. The supplementary conditions are almost never the same. So it's really important when you're reading the contract for those first few times that you remember that your general condition clauses are going to be overridden by the supplementary condition clauses. So marking up or looking at them in parallel is important for those first few passes.
Thank you, Trevor. And Geza, I think you probably the person on the panel that does this for a living. Maybe you could share some. You didn't come out of the womb knowing how to read these contracts. Give us some pro tips.
Sometimes I feel like I did come out of the womb reading. Anyway, well, here's how I do it. I mean, I read it. I read a contract at least twice, and well, I begin by, as the slide says, by creating a quiet space. I mean, you can't do this in dribs and drabs. So you know, you carve out a half an hour or an hour or whatever it takes. Just and you know, if you need to go to the cottage or go to the boat, or you know, if you need to just get yourself a way to do it quietly, perfect. No interruptions, because for reasons that will become clear when we go later on about how judges read contracts and so on. Well, this will become obvious. So create the quiet space and so that you can read it at one time. The first time I read a contract, I read it pretty quickly. Now, I've read a lot of contracts, so I can read it. You know, I can read a contract reasonably quickly because I've seen this before. But even if you're a novice, just read it. Just read it quickly. Don't get hung up on things. Make a note as you go through. I always read with a pencil or a pen. You know, I make a note of the stuff that, excuse me, I don't understand, or I have a question about, or something that causes me to pause. But I don't pause there for long, because my objective in this first quick read is just to identify the stuff in there that requires further attention, the more concentrated reading which comes next. And Trevor made a great point right a minute ago about having other people lay eyes on that document. It is so important. You know, your project people are going to see stuff in that contract that the commercial people will miss, and vice versa. And it is really important that as many people involved in the project see the contract and go through this exercise, because then you pick everything up. So then, having read it quickly the first time through, and you know, ticked off those parts that require further attention, then assuming I have the time, a day or two or so later, I'll go back to it, and hopefully with the benefit of the comments of other people in the interim. And then, you know, what you have is, first of all, the benefit of the first read through. So you already have a picture of this contract, and you've identified those parts of it that require further attention. And then you can focus in on that language, get advice on that language as required. Ask your counterparty, the other person you're contracting with, about some or all of the questions that you have. It is not at all unusual in my game as a construction contracts lawyer to get on the to get on the phone and call the opposing lawyer and say, listen, with respect to clause 15 of your draft, what's the intent? You know, what do you want? Because I literally don't understand it, or I'm confused by it, something like that. Get them talking about what it is that they want to capture in the language. And 99 times out of 100, you're going to find that this need not be a confrontational conversation at all. It's actually very difficult to capture intent in language, and people do it imperfectly. And it's not at all unusual to find wording in a draft contract that's difficult to understand, ambiguous, doesn't quite capture what they mean. And so, you know, you're prompting a discussion that will hopefully get the two of you on the same page in terms of articulating what it is that you have as a common intention, and then you can tweak the language to pick up that common intention. So, and then, you do that, and sometimes it takes longer than that in a very complex contract. There's more back and forth than just once or twice, but that's the game plan. Start overview with a quick read, and then dig down on the second and any subsequent reads to discuss things that are specifically troubling you about the language, and then come to a meeting of the minds and record it in the words.
So I think I heard many things, but two in particular that I just want to underscore in what you said, Geza. One is that lawyers don't always get it right on the first time when drafting.
Right.
So ask some questions. And just because you don't know it doesn't mean it's, it's a misunderstanding. It's just, get those answers. And I think the second thing is we're all reviewing these contracts from our experience and our lens. So it's getting as many sets of eyes as you can on the project. Katie, I want to ask you about the usual excuses. What do you say to folks that come up to you with these answers? I don't have time, too busy. Sorry,
yeah, I think, everybody seems to though find the time when you have to call your legal counsel in the middle of a project to help sort out a dispute or to have an interpretation of the contract. So folks always have time at that point. But I think again, you're running a business. I think it's shocking to me how many folks make the assumption. I had, literally last week had a contractor call. They bid a job to the same municipal owner they always bid to, but now that owner has switched to the CCDC2. They have 40 pages of supplementaries. They haven't read them, didn't know them, submit, they're low, they're in this. And they didn't realize, all the terms that had changed and really the relationship that they have. So I think there's also a huge assumption that they know what they're getting into. Certainly I think, it's that time aspect. Especially if you're a sub, you might be bidding, multiple projects a week. So how are you looking at that? And I think it's peeling off the time. If you have a cottage and a boat, great, but I think it's also, maybe you're putting on headphones, you're putting a sign up on your door, you're letting people know that this is what you're doing for the next 2, 3, 4 hours. I think, certainly Geza's right. The more you do it, not to say the easier it gets, but you get the skills there. But if you're something of a newbie at it, it may take you, hours. And that time needs to be set aside, and, shutting off your Outlook so you're not getting those notifications. I think all of that's, how to drive kind of that attention to it. But yeah, I mean, there's always an excuse for not reading them. But really, I think the message coming out of this whole series is, your business is on the line here.
I've been thinking about these excuses, and those are just some of them. And I'm a little less harsh about the industry than some of you guys might be. I think lots of contractors who don't read their contracts they don't read them for the same reasons that none of us ever read a car rental agreement when we pick up our car at the airport, and none of us ever read those legalistic click things when you get a new piece of software. There are all kinds of legally binding contracts out there that we tend not to read. You ask yourself why. And I think there's a perfectly rational reason for it. The rational reason is that we are engaging in an exercise of risk management, right? And but part of the message in this webinar series, and well, before I go on there, I'm well acquainted with lots of contractors who do that kind of risk management and have done it for 20 years, and they've never gotten burned. So it's not an illogical approach not to read your contract. But here's the thing, as Katie points out, the one time you do get burned, you can lose your business, literally. And so there, I think you're going to find all of us among this panel strongly encouraging this kind of not that kind of risk management, but a prudent kind of risk management and developing what is a basic business skill. And it's not that hard.
Thank you,
Sorry
Geza.
sorry for the soapbox, but
It's a great soapbox.
and by the way, before we leave, Amber, the last point on that slide, the judge will bail me out. I cannot emphasize strongly enough how wrong that thinking is. And this is something that I've seen a lot, this attitude that, well, it doesn't matter if the contract is really one-sided and hard on me, because at the end of the day, the judge will do the fair thing. No, the judge will interpret the contract. And there have been many, many, many contractors who've been very unpleasantly surprised that the fair result of their dispute never came to fruition because the contract they signed didn't permit it. It said something quite different. So don't count on a judge to bail you out of a bad contract. It will not happen.
That leads us perfectly into my next question, Geza. But we know a contract only matters when something's gone sideways. So reading the contract from the perspective of the judge, who is that interpreter, that's really important. But can you share why? And maybe give us a little bit of a lens on how that judge does look at this contract.
Yeah, well, there are a couple of reasons why it's useful to read a contract like a judge. The first is the most obvious. There is a certain probability, hopefully a low one, that a judge will actually read your contract at some point. So good to anticipate that. But much more significantly in practice, how a judge reads a contract is how the law requires the judge to read the contract. And how the law requires the judge to read the contract is how the industry has effectively mandated that. What is a very important thing for people engaged in commercial enterprises? Certainty of commercial relations. Certainty. And so these rules, and they're sitting on the slide there, they're very simple. These rules are designed so as to ensure that everybody in a contractual relationship is literally singing from the same song sheet in terms of how they come at a written document and a written contract. So it is not your subjective interpretation that counts. It's the objective interpretation of an independent third person, the judge. So, what are the rules? Well, the basic rules are on the slide. They're not that complicated. Judges read the whole contract, everything. You can't pick and choose the good stuff and ignore the bad stuff. It doesn't work like this. Everything in the contract matters. A judge's job is to take all of the words and make sense of them. And sometimes that's a difficult task, but that's what the judge is going to try to do. It's going to take all of the language of the entire contract and try to make it into a sensible whole. The approach to the language is as the slide says, a practical common sense approach. That's right out of a Supreme Court of Canada decision recently on the question of interpreting contracts. It's a practical common sense approach. Words are given their ordinary grammatical meaning. The corollary to that is, if some word in a contract has an unusual meaning or something very peculiar to your industry or your sector of the industry, best to define that, because otherwise it'll be given a different meaning. And finally, if there's any doubt about the meaning, you look at the circumstances of the case. And the example that I carry with me about that is, for example, the use of the word supply. If party A undertakes to supply something to party B, does that mean deliver the equipment and material, or does it mean deliver and install? And the word supply in a badly drafted contract can be ambiguous about that. So you look at the circumstances. A manufacturer of a piece of HVAC equipment supplies usually by delivering the equipment. A mechanical and electrical subcontractor charged with the responsibility of delivering an HVAC system usually supplies and installs. It's that kind of thing that where you look at the surrounding circumstances to deal with doubts. Hopefully there won't, a good contract will not have any of those, or very few. Anyway, that's how judges read contracts.
Thank you, Geza. That's it's a great lens just to know it's just a common sense application that the judge is going through. And we can always, well, sometimes we could get a little bit stuck on the legalese, but if we just read it from a common sense perspective and try to define those terms that we don't understand and come to a if we don't know the outcome, try to define it, then that's a good sense of if this is a good contract or not.
Yeah. Yeah.
The only thing I'll add on, that was all excellent advice from Geza. Just on the note about the judge reads the whole contract. Another thing to keep in mind is what documents are not part of the contract. It's often assumed that all the documents that are thrown in with the RFQ or the RFP, those are all part of the contract, which is not necessarily the case. They're not listed as contract documents. So for example, like geotechnical reports or hazardous material reports, which are often important if we're making a differing site conditions claim. It's like, well, what were the established existing conditions? Which if those geotech reports and hazard reports aren't contract documents, you can't make a claim that it's different from them. Yeah, similarly from the winning or successful proposal, whether or not that's included as a contract document often varies, and pointing to, well, you said this in your proposal as part of the claim, well, that may or may not be a contract document. So just also knowing what's not part of the contract is also essential.
What's not a part of it in the priority of those documents as well.
Mm-hmm. Yeah, and order of precedence between all the contract to resolve any conflicts. Also critical to look at.
Katie?
Yeah, just building off of what Geza said about, definitions, not everybody reading and interpreting that contract might have the same level of expertise and experience in construction. So what might seem obvious to us who do this for a living may not be obvious to the judge opposing legal counsel who, may be a commercial lawyer and not have the same level of expertise in construction. And I think that was just a really great point from Geza of it's the common sense interpretation, maybe not, exactly what we have and consider in construction itself.
So what should we look for when we look at a contract? And maybe I'll start with the contractor, or Trevor. How do you, when you start a contract, what are you looking for?
Yeah, obviously the price, scope, schedule bullets, it's kind of where everyone goes to. As you read more and more of them, you can see kind of the similarities and what the norm is. And if a clause feels very unfair, very one-sided, I'll usually refer back to CCDC language and the guides that go along with it to sort of see what the recommended industry standard is, to help you gauge if it feels fair or not. And starting with the supplementary conditions, again, as you read more and more, those are often where the biggest gremlins are hiding, is in those supplementals that are changing some of that standard form recommended industry clauses.
Robert, if a contract doesn't feel, I guess, right, does that tell you something about the owner and maybe the behavior of the owner?
Yeah, unfortunately, it's becoming more and more commonplace that these contracts are getting more and more one-sided, and it feels sometimes that these risks aren't landing with the party best able to control them, that these risks are getting passed down kind of to the subcontractor that's least able to assess and identify those risks. As general contractors and owners get more and more sophisticated, which is again some of the value that CCDC adds with their standard form contracts, which are intentional in being balanced and were derived from consensus of industry of this is who should hold that risk, with lots of court precedents as to why that's the case.
Thank you. And Katie, from your sense as a former recovering contractor, but now on the best practices committee, what are your lens on this?
I think, the lens, I'll just say, from coming out of BC, a lot of the supplementaries that we're seeing now from owners, especially as they move into the new 2, are all inserting themselves as really above the consultant in interpreting and determining the contract clauses. So instead of having that neutral third party arbiter, of the big C consultant, we're now seeing the owners being able to determine, their own contracts, and yeah, like I said, inserting them into that process. I think the other part, price, scope, schedule, absolutely, but it's not just the schedule of the construction project itself. It can also be, the timeline for payment, the timeline for notice in writing. I think that's another item that needs to be looked at, because you could be giving up your rights pretty quickly, if you're not adhering to those stated timelines. Yeah, I think another piece, I think this is boring, something Geza said to me at the CCA conference, that, BC, we're stuck in the Stone Age. We don't have prompt payment. Unfortunately, it's not even on the horizon right now. So, you could be very hindered in your ability to get the release of your holdback, depending on what those supplementaries say, and what kind of conditions they place around it. So that's another, I think, big issue. And then certainly on the sub side of things, how easy or how difficult it might be to get progressive release of your holdback. And again, that's a unique to BC situation, as we don't have prompt payment legislation.
BC isn't unique in not having prompt payment, unfortunately, but it's also not a coincidence that our next 3 sessions are focused on time, scope, and money. Everything seems to turn on those 3. So maybe Geza, any last comments on this topic?
Yeah, on the how does the contract feel business. Let me ask the audience. It's a rhetorical question, but have you ever had the experience of excuse me, you've met a new prospective counterparty, somebody you want to do a deal with, and it's great. He's a great guy or a great lady, and you've had a wonderful meeting, and everybody is very friendly, and lots of optimism and good vibes all the way around. May or may not be enhanced by the beer that you're drinking in the pub while you're having these commercial discussions, but everything is fine as you're discussing this exciting new contract that you're about to embark upon. And you leave the meeting with the other guy saying, well, I'll send you my our usual draft contract. You can have a quick look at it, just sign it and send it back. And then a few days later, you get this thing on your desk that bears little resemblance to what you talked about in terms of how you expected your commercial and personal relationship to actually unfold. It's all about all for me, none for you. The draft is full of difficult language, like difficult for you, very onerous provisions, and you read it and you wonder where this came from, remembering the great time you had the week before at this meeting. And occasionally I find myself advising a client who is in this position, and the advice I give them after talking about it is, listen, in my view, you have a threshold question here that you have to answer. And the threshold question obviously is it worth going down the road with these people any further at all, having regard to what it is that you've been presented with? I mean, think about what this draft contract with all of these onerous terms are signaling to you about them and about how they view their relationship with you in reality, not how they presented it to you in the pub, how they're going to view it in reality in the field. And now oftentimes these onerous contracts come because the other side really hasn't read them either. He or she has gotten it from somebody else up in corporate, and nobody's really thought about it. And it's possible to go back to them and say, listen, we have issues with this, and you can actually get somewhere in negotiating a deal. Other times when you try that and you encounter significant pushback or excuse making, well, that's our standard form, we can't change it. Then comes the threshold question, which is, do I really want to do business with these people at all? And that to me is a very important question that all contractors should be asking themselves when they're reviewing, particularly these onerous provisions that we're seeing more and more of.
I'd be surprised if most of the participants haven't had experience like that, Geza, but out of curiosity, maybe if you have had that experience, please throw yes in the chat box and let us know. Katie, you were going to mention something?
Yeah, just, I think the time, and we're going to reiterate this a couple of times, but the time to ask questions about, let's just say, the supplementaries or the contract is before you sign it, after that beer. So I think what I hear from owners a lot is, two things. One is the contractors, after they sign in the middle of the project, something happens. That's where they're trying to negotiate the contract terms. And the other part from owners that I hear from is, well, have they even read this contract? Here we are in the middle of the project, and I'm referring back to something that's stipulated and they've agreed to, and it's as if it's the first time they're hearing it. And it may very well be the first time that contractor or sub is hearing it. But I'd flip that from, what I've heard from owners about their experience on contractors reading or not reading and asking for exceptions after the fact.
Thank you. So contract, they can sometimes feel like you're walking into a giant landmine, right? But how can we spot the hidden traps? And maybe I'll start with Geza on that one.
Well, let's start with the proposition that there are no hidden traps, because there aren't. It's right there, but you have to think about them. you have to read the contract and you have to think about them. And so I don't believe that a contract contains a hidden trap. Language is right there, but the things to look for, when you're going through your exercise of the quick read, imprecise and subjective language. Imprecise language is kind of obvious. For example, the word reasonable. Now, it's hard to get away from the word reasonable in a contract, but there are places where it's more appropriate than others, and so you just have to, note them. Subjective verbiage is always a red flag. Words like in the sole and unfettered discretion of the other party. Well, what in the sole and unfettered discretion? Their assessment of whether or not you get paid. I've seen that kind of thing. Be on the lookout for notwithstanding. The word notwithstanding in a contract, because it's potentially problematical. What notwithstanding means in a clause is, no matter what else, either in the contract or in this clause or somewhere that's presumably defined after the word notwithstanding, no matter about that, this is what governs. So you got to be careful about notwithstanding language. Just note it and think about the implications of it. Notice provisions are very important. Notices of claims, notices of delay events, they are prevalent, and they are often traps for the unwary. In Ontario, in particular, the law in terms of compliance with notice provisions where you've got a claim or a delayed claim, for example, or a claim for additional payment, are quite strictly enforced to the point where it's really quite unfair in many cases. But that's the law now in Ontario. It's a bit better in BC. And other things to look for. Anything that you don't understand. And there's no shame in not understanding. There is legalese in contracts. There are words that have a very precise legal definition, like the word indemnity. And there's no shame in not fully understanding necessarily what they mean. Just note them, and then you know what to ask when you consult with your advisor. And the point is, it's up to you to understand what you're signing, and to ask all of the questions necessary to get to that point of understanding.
Great advice, Geza. I'm going to move on to the next slide. Just for timing. So the next slide, although it's not popping up for me, is what about subcontractors? So it's I think a lot of what we spoke about today, they can apply to both prime as well as subcontractors. But what do the subs on the call have to consider that's specific to them?
Maybe I'll start that off. I think first off, they're probably going to have a lot more to read. And that's because, 9 times out of 10, if not a whole heck of a lot more, there's going to be that flow down provision from the prime to them. And I think that, again, puts that challenge on the amount of time that it'll take to read all of these. But that is such a critical aspect to understand is, get that prime contract. Because really, again, like your livelihood might depend on it. And maybe I'll hand it over to Trevor to expand on that more as from the GC lens.
Yeah, for sure. Yeah, unfortunately, subs, they not only have to read the general contractors standard forms of contract they're bidding against, also getting their hands on the prime and really understanding where the general contractor could potentially get back charged and understanding that could flow down against them. So if there's liquidated damages or non-performance delays or back charges tied to scheduled delays and the limits of liability that go along with those, really having a good sense of what that is and what the entire agreement that they're entering into by signing up for this project is critical.
Yeah, I like Katie's comment about subs having a lot more to read. It's true. It's so true. And guys, as trade contractors, you're the ones doing the work. And at the risk of being controversial, you're the ones who are making the real profits compared to the GC. So, yeah, it's your responsibility. And these flow down provisions are often traps. And if you don't know about them, you're flying blind. If you do know about them, you can price it. You can manage the risk. So another reason to read.
And I think asking the time to ask for a prime contract is not in the middle of the project or the end.
No,
it is at the beginning. And if that GC or the owner is putting up a barrier to you receiving that, and there is, flow down provisions, like red flag, huge red flag.
Huge red flag. There should be no hesitation on the part of a GC in providing, assuming the GC wishes to flow down, prime contract provisions to the sub. There should be no hesitation on the GC in providing the sub with all of the contract documents that the GC is signing with the owner. Now, usually they're redacted to take out the commercial terms because the business, the price between the GC and the owner may not be public or need to be. But everything else, there should be no hesitation. And if there is, that is a red flag. And yes, ask for it before you sign the contract. Getting the prime contract after you've signed is too late. You're bound.
Thank you, Geza. And I think we have just enough time for a few questions. So it's the last call for questions. If you have any, please put them in the Q&A, but I will go through a couple of the ones that are on there right now. Will a copy of this presentation be sent to participants? Absolutely. This is also being recorded and you will get a copy of the recording as well. A couple of great comments. One is from anonymous attendee. I think the biggest trap is not the contract, but rather the unreasonable amount of time given often for reviewing the contracts and the supplementaries, i.e. added at the 11th hour and hundreds of pages, 600 to 700 page project manuals and plans with a 30-minute site walk, 48 hours for questions, and a week to bid. I think that frustration is felt by a lot, and we kind of agree with that. Trevor, as a contractor, I'm sure you've been in that situation and can commiserate as well with this group.
Yeah, totally. It's the amount of documents that get thrown at you sometimes on these RFQs or RFPs. It's just not enough time to give a proper look through everything, and you're forced to prioritize and look at the key documents and try to identify those key risks.
And Trevor, there's another question for you, but I think anyone can really address this one. It's, can Trevor expand on the statement around supplemental documents not being contract documents and included in an RFP?
Yeah, sure. It's typically in the front end of the agreement, in the articles, it'll just explicitly state what the contract documents are, which CCD will suggest what those typical ones are, that are agreement, or general conditions, or supplementary conditions. Sometimes your supplementary conditions will capture other documents as well. But without looking at that closely, some people just take for granted that anything that flowed through in the RFP is a contract document, and that's not the case. It's only what's explicitly stated in your agreement as contract documents.
Yeah, it's not unusual in negotiating a contract to have lots of paper flying back and forth at the front end. You know, requests for proposals, letters modifying the proposals, letters, you know, excluding things, emails, all kinds of stuff. And amid that what can be a lengthy negotiation, it can get very unclear as to what exactly it is that the parties finally landed on, and in terms of their contract. And there are many cases where there have been prolonged and very expensive disputes simply about the issue of what it is that the parties agreed upon or didn't agree upon, whether or not an exclusion in an answer to a proposal applied or not, and so on and so on. And again, as I mentioned, a while ago, a judge is going to look at this objectively, and he or she is going to look at that trail of paper and is going to look at the contract that you signed and the list of contract documents that presumably are sitting somewhere in that contract, and is going to say, yeah, that's in, or no, that's not in. You know, I know you guys talked about it, but that's not what this paper says you finally agreed upon. And that's what the judge is going to enforce. And CCTC does a very good job, actually, and most good contracts now do a very good job of making sure that the list of documents intended to have contractual effect, the contract documents, are explicitly listed in the contract, so there's just no dispute about this. But it's a common problem if you're not careful to monitor it.
Yeah, I think that's a major topic in our Q&A there, Geza, but a question asked was, can exception or assumption letters issued by the GC to the owner become a part of the contract when issued with the bid? I think the answer is depends, but I think you just kind of alluded to it.
Yeah. Yeah, the point is to be clear about this. That's the point. And, this takes us right back to that the value of negotiating a written contract, because the exercise of getting clear about that before you are engaged in a legal relationship is infinitely preferable to fighting about it later, to state the obvious.
So another question we've got from our audience is, can you argue that a big project contract, which is live over the course of many years and has had many revisions, can evolve to something that is in a conflict of itself? Guess best practices to manage it. I think what you're hearing in Geza's laughter is lived experience of this question. I think Trevor or Katie, feel free to answer that one as well from your contractor experience.
Well, I think the silence maybe speaks volumes to that question. I think maybe for me, going back to what Geza said, or I can't remember, it was Trevor as well, about getting these agreements in writing, but the multi-year contracts, I don't know, maybe as a best practice, meeting every 6 months to confirm everyone's understanding of all of the contract documents. I don't know, Geza, Trevor.
That is such a great question, and because it gets right to the heart of the construction process, which, as we all know, is dynamic. Things change, and where you have a long-term project, well, that dynamism just comes home to roost, does it not, in so many cases? And so, the understanding, the contract that you entered into 5 years ago just ain't working today for various reasons. In the United States, there's a doctrine called cardinal change, which is not, to my knowledge, not really taken off in Canada. And the basic idea is, if you've got a long-term project, or there have been so many changes to the project that what you ended up with is just not what you started with, and so you have to look at it from a different lens. There's some scope for that in Canadian law. It's not as well developed here as it is in the States, but it is a problem. And but this harkens back to another really important thing about contracts, particularly long-term contracts, and that is, what are the change mechanisms within that contract? All good contracts have change mechanisms, change orders, change directives, whatever. And it is very worthwhile to do two things. When reviewing the contract, read and clearly understand those change mechanisms and make sure that they're sufficient for your purposes. You have to kind of think ahead about this and consult with your project people to make sure they can work with them. And the second thing is, follow them. And if that means delivering a notice, if that means, whatever is required, follow it. It's when parties depart from the change mechanisms in their contract and kind of start making it up as they go along that you end up in huge disputes, and nobody wins except the lawyers on those.
Thank you very much, Geza, and Trevor and Katie, thank you also for joining us today, as well as all the panelists. There was a great question in the panel that unfortunately we won't have time to address in the QA, but the question was, in your experience, what is the best way to negotiate or manage a subcontract term that uses the language inferred scope? And for the answer to that question, I think you need to join us in a couple of weeks, because we have a brisk session of reading your contract, just solely focused on scope definition and change management. So with that, I'll wish you all a really good rest of the remaining afternoon.